What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com, and I wanted to make this quick video to talk about debt collectors and original creditors. I get this question a lot on YouTube, and a lot of people find themselves making their situation worse because they don't clearly understand what direction they have to go when fighting a debt collector and an original creditor. Someone had posted a question and they said, well, if it's the original creditor, am I just stuck and I have to pay it? Uh, in, in a sense, you're going to have to pay it if it's not past statute of limitations, but you're not stuck. And I'm going to talk about the solutions at the end of this video and what you can do. So the first thing that you got to do this when you get uh, when you have a debt collector coming after you. Now, well, actually, it's further down the line, but the first step is where you do a validation and you want to find out if they own the debt or if they're assigned the debt or if they are contracted. Because when you find out those three, you'll be able to know which direction you're going to go to fight, to fight this debt. So the first thing is if they own the debt, have they bought the debt from, where they sell these portfolios and they buy a whole batch of old accounts, or were they assigned a debt, which you'll see where one debt collector in your area is actually the assignee from a debt collector that buys debt nationwide. And they just went to that debt collector in your state because it's they're in your area, they have someone in your area, and they'll manage all of the debt that they buy in that area. Or are they contracted by the original creditor? And that's very important. Are they contracted by the original creditor? Because if they are contracted by the original creditor, this is a whole different type of fight. And I'm going to go with what you got to do on that. So now, first, if they own the debt, you're going to do a debt validation. If they own the debt or if they are assigned the debt from a debt collector, and you got to make it clear when you look at your if you're being sued and you have a court summons, it'll have a debt collection company name as the plaintiff, or does it have your original creditor as the plaintiff? If they have a debt collector as the plaintiff, then you're going to do a full debt validation slash you want to make them prove that you have to pay them. So you want to have some type of contract. You want to have the transfers from one company to another. Uh, you want them to disclose all of the charges. You basically what you want them to do is to give you everything as if you were dealing with the original creditor, but you want to make them have all of that, prove all of that documentation by giving it to you. Now, they might not try to send it to you, or they might try to send you some bank statements or some little stuff, but this is where the back and forth happens because they know, trust me, debt collectors know that they cannot try to come after you when you've made requests for documentation and they don't provide it. If they haven't taken you to court yet, it's going to just be a lot of back and forth, and they may never take you to court. If they've taken you to court, then it's going to be some back and forth, and it could end up being a stalemate where they just put the hearing off, where they just say, we're not going to schedule a hearing until we get all of the other information that you requested. Basically, what debt collectors try to do is if you get into that back and forth with them about getting documentation from the original creditor, they will either dismiss it or they will try to delay because they can't get the information. And then if you take a step further, where you make them prove amounts by saying that they swear to the accounting that they're trying to come after you for. Because remember, in a summons, this is an allegation, and they have to prove that. They can't just say it. They have to give documentation, and some of the documentation is almost impossible for them to prove because they did not work for the company that provided the documentation. And if it's 2 levels deep or 3 levels deep from one debt collector down to another debt collector. That debt collector in your area is usually taking the word of the debt collector that sent them the debt, and then that debt collector has to go to their uh, original creditor that they purchased the debt from and get that information. That's why it can actually extend out the period of time to even get this stuff done because they're just going back and forth. So this can always take work. Doing this stuff can take work, and what debt collectors depend on is that people just get frustrated and they quit and they think that just because you send something and the law is written this way that a debt collector or a company has to follow it. We see stuff all the time where companies or uh, people don't follow the law, and you can see that it takes a long time for stuff to get worked out. So now, if you're dealing with the original creditor, where they've contracted a law firm in your area to sue you for the debt, and this is an option that they have. They don't always have to sell the debt. And then when that happens, you're basically what it comes down to is if you disagree with the amount that they're claiming. And what you would do is you would just do a full debt validation to for the amount where you just want them to send you everything to prove that you owe that amount. And then the next step would be to go into a settlement. And that's where we're gonna go. Well, before I get to that point, with original creditors, when you're dealing with original creditors, you're basically looking at balances if you don't agree, or if there's something that you disagree with the way that they handle your account, your file, any types of stuff like that that you believe is a legal issue, you can bring up. Uh, you can bring up against them and just see what maybe could potentially be worked out. But 9 times out of 10, when you're dealing with an original creditor and you're taken to court or even before court, you need to push to try to work out some type of resolution. Now, one of the questions that someone had was, what if I don't have the money? I don't have the money to pay the original creditor. What can I do? What you should do is you should call them and open up the line of communication and notify them of your financial situation because they're more likely not to proceed, not to say that they won't, but they're more likely not to proceed if they know that you have financial issues because they don't want to spend this money and not get anything. When a company is contracting uh, contracted lawyers, they're paying money and they don't want to pay money when they know that they're not going to get money when they just lost the other money. It's different for a debt collector because they pay pennies on the dollar and they're just investing some money to take you to court. But when the original creditor has lost the original principal, and then they're going to pay a firm, which they're paying them a retainer. They're not usually paying them on commission, so they don't like to really keep going after it like that if they know that they're not going to get the money. So if you open up the line of communications, and you tell them your situation that you can't afford it, sometimes the original creditor, when they get that information from that from their attorney that's handling it for them, they can make a decision to write this off as a 1099 sometimes, sometimes. And that's where the debt will just go away, but they're going to put it on your own, send it to the IRS, and you're going to have to pay taxes on that. But if you don't make enough money, you can get a waiver on it. But this is the way that you can kind of get a company to do that. A lot of people get confused. They think that when a company does the write-off, that they've actually done the 1099, and that's not true. They have not sent it to the IRS to say that they're going to do what's called a debt cancellation and get that additional write-off. I don't even know to this day. To this day, I'm gonna have to look this up. To this day, I don't even understand the full write-off process because they can write it off and they can get charged. They charge it off and then that's put into the accounting records as bad debt. But then they can write that off on their books and then they go and then they do a debt cancellation where they choose not to sell the debt or package up and sell the debt, and then they get some other type of write-off. I'm not sure how that works. I'm going to have to look that up. But if you open up the line of communications with the plaintiff attorney for the original creditor, you can either get a substantial settlement opportunity, or they can just say, this individual doesn't have the money and they're going to do a debt cancellation, or they might just take it back and put it into the pile that they're going to sell later to debt collectors. Those are the options of the original creditor. And just so you know, just so you know, because I get a lot of questions on this, you cannot force an original creditor to do anything. You cannot force them to send it as a 1099. You cannot force them to sell it. You cannot force them not to take you to court. You cannot force them to uh, do a settlement. Basically, they're going to do what they want to do based off of what they're doing with those accounts that your account is attached to. They, when your account goes bad, it is not looked at as you as an individual. You might think it when they try to call or send you a letter in the mail or something, but it's not. They're just trying to do resolutions on batches of bad accounts, and they're either trying to contact you through a debt collector to do something about it, or they're selling it in batches to debt collectors so they can try to do something about it. So don't think that you're going to force them into doing anything. And I think that's what happens with a lot of people. They get frustrated because they think that they can control what other people do rather than just controlling what you control. What you control is you control the outflow of questions, of paperwork that you ask them to either provide if you're sending it to debt collectors, or you're sending it uh, you're sending it to debt collectors, or if you're sending it to the original creditors. You control the outflow of what you're asking for. And when they send documents back, you control what your responses are to the questions or whatever statements they make. And that's the same thing if they take you to court. You control what you ask, they control what they ask. A lot of people get that flipped around and they think that, well, they said this about me, this, that, all that type of stuff, and they get upset and they're like, how can they say? Don't worry about how they can say it. Worry about what you can do to come back at what they said. Because don't get stuck in what people say about you. That a lot of people get stuff flipped around, and that's why they never get anything done, because they sit there worrying about what other people said about or what other people did, rather than saying, what do I control about taking care of what they said and what they did. And there's certain things that you don't control, and there's certain things that you do control. So to sum it all up, when you're dealing with debt collectors or assignees for other debt collectors who have purchased debt, you control everything from asking, how did they get in control of that debt? Show me show me a contract between me and you, Mr. Debt Collector or Mrs. Debt Collector. And then prove every aspect about the debt that you're claiming. Everything, balances, interest rates, my payments, my credits, my signatures on any charges or anything that you're claiming on this debt. Get that to me. Let me review it. Let me review it. And then usually, if you keep pushing that way, it'll either get to a standstill, or they might get all of the information and you go to settlement. On the other side, if it's an original creditor, they hired a law firm to come after you for the debt. Then you want to get everything, but original contract, unless you believe that there was something wrong with it, original contract, that's, you can ask for it, but that's just information that they're going to have readily available for you. You're basically challenging the debt if you believe that there's a problem with the debt. If you don't believe there's any problem with the debt, you might as well skip right over. If you're having a financial problem, call that debt collector and let them know, I'm having financial issues. I'm not going to be able to pay it. We'll follow up with you at a later date. The debt collection company that's hired by the original creditor will contact their client, say, what do you want to do about this? This is what they said. You should also send that in writing so they can get it to their client. Make sure that it gets to their client. Some of the times they try not to get it to their client because they're trying to say that they don't believe you, because they're getting paid a retainer and they're getting money every month. So you want to make sure that the original creditor who hired the debt collection company gets your information. You can even send them a letter and say, "Hey, I notified your debt collector that you hired, uh, and this is my situation. I just want to make sure that you got it." And that can force, not when I say force, it can get them to make a quicker decision on what they're going to do about your debt, to focus on your particular debt and say maybe we should just do a 1099 on this, and this is nothing. We're not going to get anything from it. Or they might dump it into a batch of old debts that they're going to sell to debt collectors, and then you're going to just have to go through the process that I mentioned before. But all of it, bottom line, so you don't go chasing around YouTube for other videos on what to do about the debt. You don't have to do that. You can just stick here with my channel. Is that you could end up having a settlement at the end so you can move forward, or they might cancel the debt and do a debt cancellation, and then you deal with it from the IRS side, which you can get a waiver. So I would like to thank you for your time. If you need help with your credit, please visit thecreditrepairshop.com. Watch the video, What Makes Us Different. If you can follow that process, then we invite you to become a customer. If you can't, please choose someone else, because we do it our way, not your way or not someone else's way. And then if you need your credit reports and scores, get your credit reports and scores, because everything starts there. Everything starts there. Get your credit reports and scores. Go to the number 3scores.com. I'd really appreciate it. And if you need debt validation letters, if you need cease and desist collection activity letters, if you need statute of limitations letters, the link is below this video. Go there and grab it. Thanks again. This is Stephen A. Williams, President and founder of the creditrepairshop.com. Thank you.